happens in that appeal, we can be appellant, my lords. We can
No,
be
no, no,
witness
no.
or not be
You file your
appellant.
appeal. We have allowed you to file appeal. You file your appeal. Okay.
So, my lords, we have filed item 2 is that only, my lords, if I'm not mistaken.
Item two is by a different person. No, item two is.
It's them.
Okay, okay.
Yes, my lord.
In view of the order. Dated. What is the date today? Dated 9/2024. Passed in IA number 62/2022. The appeal is admitted for hearing. There is one analogous appeal.
Yes, my lord, it has to be tagged with writ appeal number 7 of 2023.
Take the instant appeal with read appeal.
Appeal number 7 of 2023.
Appeal number 7/2023. Okay.
Yes. Much obliged, my lord. Much obliged.
Yes, please.
By please, Your Lordship.
Ah.
I beg to mention item number 11. Affidavit in reply is yet to be filed. So I believe 2 weeks time may be granted.
Mr. So-and-so, learned counsel for the petitioner submits it. He may be allowed 2 weeks time to file affidavit in reply. Where is all listed the court.
Your Lordship, similar prayer for item number 16.
Same.
Yes, Your Lordship.
Same order. Same.
God bless.
Please, Your Lordship.
Yes, please.
However, in respect of item number 27,
Ah.
I've just been informed by the learned senior constable at the site that he has to go outside for some treatment. So may I please this be fixed on 7th of June?
7th of June.
Council is there.
Mr. So-and-so. Learned counsel for the petitioner submits that. Mr. N.K. Likam. The leading counsel for the petitioner is indisposed. And therefore seeks adjournment of the case on 7/6/2024. Where is allowed? Listed accordingly. Okay.
Bless your Lordship.
Yes,
Lordship,
Mr.
I would like
Kumar.
to, yes, mention item 24.
Ah.
Mission
Ah,
and representing the state here.
ah.
I mean, we are allowed, Lordship, 3 weeks time to obtain instruction in the file state form.
Yes, Mrs. Lee. Mr. Moimchan, the Learned Senior Government Advocate, is allowed 3 weeks time to obtain instructions and to file affidavit if so advised. Listed accordingly.
Published.
Lordship, with the
Yes.
consent of the other party, I beg to mention item number 36. My senior TB Jamir is out of station, so matter may kindly be fixed on 21st of May.
36.
Yes. I'm for respondent number 4.
MS so makes a mention on behalf of Mr. TB Jamir, the counsel for the respondent number 4. Respondent 4.
Yes, Lordship.
Respondent 4. And seeks adjournment of the case after a week. Prayer is allowed. Listed accordingly.
Lordship, interim may be continued.
Okay, the interim order passed earlier shall continue till the next returnable date.
Lordship, 21st May.
30, oh, listed after, listed on 31/5/2020.
21st May.
21st May,
Yes.
2020. Okay, okay.
May I please, Your Lordship?
Yes, please.
Your Lordship, I beg to mention item number 19, 2021. Yesterday, I filed my reply, so let the matter be come for admission hearing after 3 weeks.
19,
2021
2020. You are the counsel for the
petitioner, Lordship.
Mr. So-and-so, learned counsel for the petitioner that he has filed the affidavit in reply. And the copy has been furnished to the learned counsel for the opposite parties, to the respondents. Stop. Since it is submitted that pleadings are completed, listed for hearing in the usual course. Okay.
Much.
May it please your Lordship, I
Yes,
beg to mention item number 34. I'm appearing on behalf of my senior learned advocate N. Longkumar. Wherefore respondent number 4, 5, and 6. Your Lordship, kindly drain us 2 weeks time.
34, man.
Yes,
MS so-and-so. The learned counsel makes a mention on behalf of Mr. N. Longkumar. The learned counsel for the respondent number 4, 5, and 6. And 6 adjournment of the case after 2 weeks.
yes. Your
Where is
Lordship.
allowed? Listed.
I praise your Lordship. Lordship, I beg to mention item 14. Lordship may be gracious enough if this matter can be come up after 3 weeks. Where you have to file an affidavit in reply, Lordship.
You are the counsel for the petitioner.
Petitioner.
Mr. So-and-so. Learned counsel for the petitioner, 6 for 3 weeks time. to file affidavit in reply. Prayer is allowed, listed.
Much obliged.
Yes, Your Lordship.
Yes,
I beg to mention item number 26.
Huh.
We've just received the affidavit in opposition filed by respondent number 1, 2, and 3. Also, Lordship, the service upon respondent number 9 is still awaited.
let it come as per the list. Let us see. Yes,
So Lordship,
yes, please.
Lordship, I'd like to mention hearing item number 31.
Item then,
Hearing item number 31.
3-1.
Lordship, my senior has some personal difficulties.
Your senior, who is your senior?
More Jamia. This matter can be decided after 2 weeks, Your Lordship.
MS Sensu. Learned Counsel makes a mention on behalf of Mr. Moajamia, the counsel for the learned counsel for the petitioner, and seeks adjournment of the case for 2 weeks on the ground that Mr. Moajamia, learned counsel has some personal difficulties. Prayer is allowed, listed after 2 weeks.
Lordship, similar prayer for item number 33 and 35.
33 and
35, Lordship.
so Joshua, you are appearing? Okay, 33, 34. Same prayer. Same prayer.
May it please Your Lordship.
Yes, ma'am.
I'd like to mention item number 15.
1-5.
Here, I won't be filing my affidavit in reply to the affidavit in opposition filed by the state.
Your good name?
H. Chiliang.
H. Zillian. Okay.
I pray that this matter may be listed for hearing after a week, Your Lordship.
MS Sensu, H. Zillian, learned counsel for the petitioner, submits that the affidavit in reply will not be required, and therefore submits to list the matter for hearing in the usual course. List of the court. Okay.
Yes,
Yes,
My please, Lordship.
yes,
Lordship, I beg to mention item number 22. Lordship, Lordship, we are yet to file our affidavit in reply, Lordship. So kindly grant us 3 weeks time, Lordship.
CGC.
No, Lordship, I'm on behalf of the petitioner, Lordship.
Oh, okay.
I've already taken the consent from the CGC.
Mr.
Lordship.
Sensu, learned counsel for the petitioner, submits that some time may be granted to file affidavit in reply. Where is allowed, listed accordingly, listed on,
After 3 weeks, Lordship.
listed after 3 weeks.
There's an interim, Lordship.
The interim order passed earlier shall continue till the next returnable date.
Also, pleasure, Lordship.
Okay.
May I please, my lord?
Yes, Mr. Nangami.
Lordship, I beg to mention item number 25. Lordship, I'm here to receive instruction in this matter.
Yes, Mr. Iralu. 25.
25, my lord.
How much time
3 weeks time, my lord.
to give? Mr. Nangami, the learned senior government advocate, is allowed 3 weeks time to file affidavit. Okay.
Deeply obliged.
The interim order passed earlier shall continue till the next returnable date. Yes.
Mention hearing item number 13, Lordship.
Yes,
This matter can come up next week, Lordship.
next week. Mr. Rij Momi, the learned government advocate, seeks adjournment of the case for a week. Prayer is allowed, listed accordingly. Okay.
Lordship, I also beg to mention item number 6 and 7, Lordship. Here, Lordship, the petitioner they have filed the amended petition, Lordship. And to that effect, I'm yet to receive instruction. Lordship.
6 and 7.
6 and 7.
Mr. Rij Momi, learned government advocate, submits that he is yet to receive instructions on the amended petition filed by the petitioner, and therefore seeks for 3 weeks time. Stop. Prayer is allowed, listed after 3 weeks.
Lordship, I also beg to mention item number 8, Lordship.
Slowly, you are eating up everything. Yes, Mr. Joshua.
Your Lordship, here the affidavit from the finance commissioner.
Ah,
My lord, in fact, it's just a formality, if not the low points. Not the picture of the case doesn't change by the affidavit filed by the finance commissioner, who has been impleaded as a fresh party, lordship, after the matter was proceeding before the Zalmu court.
by the orders of this court.
Yes, lordship, by the intervention of the Zalmu court, because the issue of fixation of pay scale,
Ah,
that is the issue here. The Bashis who are serving in the district of Waka, lordship, they are being paid the 1999 ROP, your lordship.
they are regular.
No, your lordship, but at least the minimum pay scale of the latest ROP, they
They are
deserve
getting
that,
scale
my
of pay at least, minimum scale of pay.
Yes, lordship, the latest pay scale, your lordship. ROP.
Oh, you want the latest pay scale,
Yes, your lordship.
but they are receiving scale pay.
Yes, lordship, they are receiving pay scale of 1999, my lord, ROP.
What is their minimum scale of pay for the Bashis
Your lordship, that,
as per the latest ROP?
my lord, I have to have a look at the ROP book and show you, lordship.
Okay, we give last chance. If
Lordship.
no affidavit is forthcoming from the finance department, the other departments, they file.
Yes, lordship,
Other departments.
So we give last chance to the finance department.
my lord,
If no affidavit is forthcoming, we list it for hearing.
my lord,
Okay,
lordship.
this is item
8, my lord.
Mr. V. Jimomi, Leonard Government Advocate, 6 for 3 weeks' time to file affidavit in opposition on behalf of the finance department. Stop. Prayer is allowed on the condition that if no affidavit is forthcoming on the next date fixed, the matter shall proceed for hearing on the basis of materials available on record.
My lord.
Okay.
Obliged, your lordship.
For motion, item number 1, 2, and 3.
Please, Your Lordship.
Yes.
Your Lordship, this IA is filed in WPC 71 of 2024, item number 3, Lordship. Lordship,
IA 64.
yes, IA 64
IA
is
64. Let us see what in which writ petition?
71 of 2024, Lordship, item number 3. Lordship,
Just wait, let me see. MS Counsel, Leonard Counsel for the applicant. The present application has been filed, seeking for correction of the address of the respondent number 3 in WPC 71/2024. Stop. It is submitted by the Learned Counsel for the petitioner, for the applicant, that the correct address should be read as the brigadier should be read, it is submitted by the Learned Counsel for the petitioner, for the applicant, that in the writ petition, the address of the respondent number 3 has been entered as the Brigadier, Deputy Inspector General, Shillong, 793001 Meghalaya. Whereas the correct address should be read as, within inverted, the Brigadier Office of the Deputy Inspector General, Assam Rifle Headquarters, 7th Sector, Assam Rifles, care of 99 APO. The application for correction of the respondent number 3 is allowed. Stop. The applicant shall file amended course title. Petition disposed. Okay.
Obliged, Lordship.
For admission, item number 4.
That is a Lordship.
Yes, what is the case? Have you filed your affidavit?
Lordship, yesterday I filed my affidavit.
Yesterday, where is your affidavit? Is it on record?
I filed it yesterday, Lordship. And I have also served the copy to the petitioner.
Yes, I have received your Lordship.
You are filing against the eviction order
Yes, your Lordship.
passed by the Deputy Commissioner.
Yes.
Then in that case, you will have to apply before, appeal before the Commissioner. That is the law.
Lordship.
Yes.
I think you have not taken recourse to the appropriate forum. Anyhow, we will hear you. Mr. V. Jamomi, the learned government advocate. submits
Your
the-
Lordship, we will file our reply to this affidavit in opposition. So kindly allow us.
It is
2
not
weeks
on
time.
record. Okay, Mr. V. Jamomi,
2
learned
weeks time.
government advocate submits that he has filed the affidavit in opposition on behalf of the state respondents. The affidavit is however not on record. Stop. Registry to trace the same and place on record. Listed after a week.
Your Lordship, there is an interim order.
The interim order, stop. The interim order passed earlier shall continue till the next returnable date. Okay.
Much obliged.
Item number 5.
Yeah, please, Your Lordship.
Yes.
Lordship, I'm mentioning on behalf of Ms. Lucinda for respondent number 6.
Okay.
Lordship will be filing the affidavits today.
Respondent number 6.
Yes, Your Lordship.
Okay. So what is your prayer? Affidavit in reply?
In opposition, will be filing today.
Oh. MS so appears on behalf of MS Lucino, the learned counsel for the petitioner, and submits that the affidavit in opposition on behalf of respondent number 6 will be filed in the course of the day. Stop. This is the case after 2 weeks.
Item number 9.
Yes.
Left is a Lordship.
Yes.
Lordship, I'm mentioning on behalf of MS Naholi. Lordship.
Okay.
Lordship,
And it is seen that pleadings are completed.
Yes, Lord.
Pleadings are completed.
Yes, Lordship.
We listed for hearing
Lordship, on 16th of this month.
on 16th.
16th.
Why that auspicious day?
Lordship, this is as per the instruction.
Maybe 16 will be quite difficult for this court. We listed on 21, Mr. Joshua, whether it is convenient for you on 21. Okay,
Your
21.
Lordship, here, no doubt the pleadings are, on record, the pleadings are completed.
Okay,
But the state respondents were supposed to give some clarification on when they can sanction the post under the Consumer Commission, Your Lordship.
oh,
So that instruction is yet to come.
by which order? By which order? That instructions was out? Ah, correct. By which? Hmm. Yes, it is 7/3/2024.
My lord.
7/3/2024. Have you also filed affidavit to this effect? Para 11, the state shall also respond as to by what time a permanent office of commission would be set up for the functioning of the Nagaland State Commissioner, Nagaland State Consumer Dispute Redressal Commission.
My lord.
Lordship, since I don't have the brief with me, Lordship, if this matter can come over 16 of this month, Lordship.
Lordship, as per the Bagla report of 2000 and the latest act, read with the latest act, my lord, the state is to bring instruction as to when they can create the post for making the commission functional.
We'll list it on 21 and we'll also direct the state to produce the instructions on that day. We'll list it for
My lord.
hearing. Okay. Yes, Mr. Joshua.
Your Lordship, my lord.
Mr. Joshua appears for the petitioner and Mr. Bijmomi for the state respondents. It is submitted that pleadings are completed. Stop. The matter is listed for hearing on 21/5/2024. Stop. On the next date fixed, the state government shall also come with necessary instructions, shall also come with definite instructions as to by what time a permanent office of the commission would be set up for functioning of the Nagaland State Nagaland State Consumer Disputes Redressal Commission as ordered by this court on 7/3/2024.
Your Lordship, if my lord may kindly include this also to the post creation, because there's not even a single post created, my lord, and the petition is about post creation, Lordship. All the employees are either on contract or casual, my lord.
What was that order? Ma'am? Last part. As to the time required, as to the time required to set up. As to the time required for functioning of the Nagaland State Consumer Redressal Commission, and also,
My lord,
क्या है?
the post creation,
The post creation against the said commission.
yes, my lord. There's not even a single post
And
created
the
for the
post
registry.
creation and
Yes,
the
Lord.
post creation against the said commission. Okay, post creation against the said commission.
Yes, lordship.
Am I right?
Yeah, my lord.
And
That
the
covers it,
post
my lord.
creation,
To run the registry, my lord.
what was that? What was that? Let us- As ordered by this court on, yes. And also the post. And also the post required to be created against the commission.
My lord.
Okay,
Lordship, I'm mentioning on behalf of Nahul.
that's all right. You're all same. Government advocate, listed accordingly, 21.
My
Since
lord.
I'm not in this case.
Okay. Tell her, 21, come prepared.
Oblige, your lordship.
Item number 10.
That is a lordship. Lordship, I'm mentioning on behalf of MS Divika Lordship.
Ah,
I'm instructed that she is yet to file an additional affidavit, Lordship.
additional affidavit.
Lordship. So if Lordship may please to run another.
Why additional affidavit? Why additional affidavit? Yes, what was the reason for additional affidavit? When was that ordered for additional affidavit?
16/2/2024.
16/2. I think it's high time. 16/2. Mr. Vijamomi. The Leonard Council makes a mention on behalf of MS Livika, the Leonard Government Advocate, and seeks adjournment of the case to file additional affidavit. Last chance of 3 weeks' time is granted to the state respondents to file the additional affidavit listed accordingly.
Item number 12.
Yes.
Lordship, I'm mentioning on behalf of additional AG in team song.
Huh.
Lordship,
Counter affidavit not filed.
Lordship. So if Lordship may please to grant 2 weeks time, Lordship. Lordship, I've been instructed that signature is awaited.
Signature awaited. Mr. V. Jamomi makes a mention on behalf of Mr. M. Timson, the Leonard Additional Advocate General Nagaland, and submits that the affidavit has been sent for waiting and will be filing affidavit on the next date fixed. Where is allowed? Listed after
2 weeks.
2 weeks. The interim order passed earlier shall continue till the next returnable date. Okay.
Item number 13.
Yes, ma'am.
Mr. Lordship. Lordship, I'm mentioning on behalf of my senior Moy Chamia.
Huh.
Your Lordship, we are yet to file our affidavit in reply.
Yes, yes.
Kindly grant us 2 weeks time.
MS Renzo. Learned Counsel makes a mention on behalf of Mr. Moa Jamia and seeks adjournment of the case after 2 weeks for filing affidavit in reply. Prayer is allowed, listed accordingly.
Item number 17.
Yes. Hearing is
Your Lord.
completed.
Yes, your lordship.
The listed for hearing.
My lord.
What was the preliminary objection?
Lordship on local study and non-joint of parties, Lordship.
What is the case about?
Maintainability.
Your lordship, we have challenged the petitioners have challenged the advertisement where age bar, the age limit has been put where the serving employees, all the serving employees being overaged could not be allowed to apply. That's number one. Number two, on the qualification, your lordship.
You are not qualified.
No, your lordship, as far as LLB is concerned,
Ah.
LLB students, if you are pursuing LLB after graduation, even in scholarship, you are paid the
What is
postgraduate
What is
scholarship.
the post and what is the requirement?
Lordship, initially also when we were appointed,
Ah.
our qualification was treated as equivalent to postgraduate degrees.
Legal cum prohibition officer.
Yes, your lordship. But that is our designation, your lordship. So equivalent to a postgraduate degree, that is why we were appointed. Now the state is coming with an argument that it is the prerogative of the state to determine whether we are qualified or not. So the question of whether that will be fair or not, when we were qualified,
There will be no necessity for you to file reply.
yes, your lordship.
Okay, we listed for
Lordship,
hearing.
but Lordship, if I may be allowed that, as far as the qualification is concerned, the required qualification that has been advertised is with regard to the new mission scheme guidelines, Lordship. Earlier, the petitioners were appointed under 2010 guidelines. However, this new advertisement, July 19, 2023, was based on the new guidelines which have been implemented last year, Lordship.
Have you challenged the new guidelines?
Yes, we have gone through the new guidelines.
No,
now.
have you challenged?
No, Lordship.
No, as far as the interpretation is concerned, that is their interpretation. We have our own
What is
interpretation.
your interpretation to the new guidelines?
Our interpretation is that since they say postgraduate, so, and your lordship will kindly appreciate this, that LLB being equivalent to considered as a postgraduate course.
No, Lordship, no, that cannot be Lordship.
No, LLM.
LLM is a
Postgraduate.
Lordship.
LLM is a graduate.
LLM is not mentioned, your lordship.
But postgraduate is mentioned.
Yes.
So LLB cannot be postgraduate. I think
Lordship.
that is the issue again.
Lordship.
No, your lordship, it's actually a postgraduate course, your lordship. LLB is a
Any
postgraduate course.
materials to substantiate that?
That-
Because just,
If
I
it is
think-
required, your lordship, I will bring it, I'll try to bring
I
it
think
in the
that
course
is
of
your
hearing,
main
your lordship.
case. That is your main case.
Yes, your lordship.
Your claim is that you are LLB, you are a postgraduate.
My lord.
Their claim is that LLB is not a postgraduate.
Lordship.
Yes, your lordship.
So I think the issue lies there.
Yes.
So come up with that, at least assist the court.
My lord,
Ah.
my lord.
Lordship, in that case, a short date may be given, Lordship. Ministry have already given for cancellation of the all proceedings of the appointment. Lordship.
Yes, Mr. Moa, you are sitting quietly.
I have the instruction, I'll be filing my affidavit.
Oh, others are ready and you will be filing your affidavit now. You have received instructions.
Yes, only they were free yesterday. For 2 weeks time. also.
Whether you are really a necessary party or whether it is between the,
I'm just a performer, respect, but
Performer,
I,
lordship.
since I received the.
but
instruction,
correct. Then we give him time.
State is given their own interpretation, so we can- in all
I
fairness,
think Mr. Younger,
In all fairness, I'm just a
Yes.
performer as well. Yes.
yes, you
But
will
I have
also,
received the
you will
instruction.
also have to take a particular stand as to whether LLB is a postgraduate or not.
It is not.
I think that you will also have because actually you are the author of that scheme.
My lord.
Correct?
Your lordship.
Ah,
His affidavit will decide whether my petition has merit or is it infractious.
correct, correct,
Lordship,
correct.
we have also filed our comprehensive reply
Ah,
as to
ah.
whether the petitioner have a locus standi, whether they are still in the service.
No,
or their
no, that
sentence
your
has been
locus standi will depend on that issue again.
My lord.
Your locus standi will depend on that issue.
Lordship, but certain documents has been annexed in our comprehensive.
So
reply.
since they are the author of the scheme,
Lordship.
and the central government is the authority who has authored that scheme, so
Lordship,
let them
lordship.
clarify.
Your lordship.
Okay. Yes. Mr. Joshua, so it will not be necessary for you to file affidavit reply
My lord, it may not be necessary.
because I'm going to
because-
record it so that we save time.
Your lordship.
Lordship, if I may be allowed for, if there be any additional to file in addition to my comprehensive reply that I.
Don't come with books.
Provision may be granted, Lordship, because we have received some more documents also.
Maybe after my affidavit, they will file that.
Okay, okay.
Lordship,
So we'll keep that open. We'll keep that
Lordship.
open. Yes.
Lordship, Lordship.
Mr. Yangawati, the Leonard CGC submits that he has received the instructions and therefore he may be allowed 3 weeks' time to file the affidavit. Prayer is allowed. listed
Lordship, may
after
date may
3
be
weeks.
fixed, Lordship.
Listed. Okay, let him file.
Lordship.
He has assured this court 3 weeks.
Lordship.
Okay, listed the court.
Obliged, Lordship.
Oblige, your lordship.
Item number 18. Yes, Mr. Kiangami.
Lordship, may I please, my lord, lordship, I'm yet to receive instructions. So kindly grant me 3 weeks' time to file counter instructions.
Okay, okay. Mr. Kiangami, the then senior government advocate is allowed 3 weeks' time to file affidavit in opposition. Okay,
Your lordship, there's an interim.
okay. The interim order passed earlier shall continue till the next returnable date. Okay.
Obliged, your lordship.
Item number 23.
May I please, your Lordship?
Yes, Mr. Longcomer, I'm seeing you after a long time.
Yes, my lord.
I hope everything is fine.
Yes, my lord.
What is your case?
My lord, the petitioner here is claiming for admitted pending bills, contract bills.
Pay,
Lordship,
ma'am, pay, if it is admitted.
Lordship, I'm appearing on behalf of Divika, Lordship.
When you want to pay something, somebody is always hiding. No?
The second time, get instructions on 4-5 occasions, and then as per the order of 12 February 2024, a specific direction was given to the respondents, directing the respondents to come up with the instruction as to when they can make the payment.
What is your case anyhow, Mr. Longcomer?
The
You
petitioner-
had undertaken some contract work
Yes, my lord.
and you have
Constitutional-
completed the work within the stipulated time.
Yes, and then.
And you have also been issued the completion.
Yes, and then
What is
the-
your completion certificate?
My lord, the work has been completed, it's only been commissioned, and then it is
Oh.
admitted, and then they have also admitted in their letter.
Where is that later? Let us see.
Page number 28,
Page number
28, in Exhibit J.
28.
Yes.
Legal, 28 legal notice
Yes, it- reply to the legal notice.
or reply to the legal notice?
So there is a letter to the commissioner and secretary by the engineer, chief engineer, my lord. Here they have.
Just wait once.
Yes.
This is chief engineer. Two and so inviting the reach to have encountered several on the president nature which were beyond the control of the department. Project skills given from time to time and have accrued a completion cost of so and so. Appreciate the commitment you have in completing the project. Despite challenges encountered while executing the project. With your vast experience in the construction of as you are well acquainted that such sites are normally located in rigorous terrains which often leads to time and cost. Further, with your long association with the department in carrying out such projects, you are directly aware of the provisional only after the proposal goes through several projects. In this connection, the government would like to inform that the completion DPR has been prepared and taken up with the government. Yes, ma'am. It is an admitted liability.
The next page, and then the page fees also. All by this all customer members everything that benefit that we said here.
To the commissioners. Successfully commissioned, successfully. Mr. MS. Mr. N. Longcomber, the learned counsel for the petitioner. And MS. S. Chang. Learned advocate. On behalf of MS Livika, the learned government advocate. Your page 29
Yes, ma'am.
and 30.
And yes.
What is it? 30 annexure? What is it? What is it?
Next is page number 31, my lord. Here.
No, you in page
30.
Page 29 is annexure K.
Yes, ma'am.
Page 30 is annexure.
This is just the enclosure of the letter of this annexure key. This letter annexure key, they have enclosed this letter 31st October and the concept of liabilities.
Okay.
This is the reply to the legal notice. So in that reply to
Seen the letter dated 23rd 11/2023 and the letter dated 31/10/2023, which is annexure K to the writ petition. A perusal of the said letter clearly demonstrates that the respondent authorities have admitted the pending liability, which is to be paid to the petitioner. Stop. Moreover, this court on 15/2/2024 had made an observation that the Learned State Council shall inform the court as to the time when the respondents will be paying the outstanding liability. Stop. As the respondents have admitted the outstanding liability, the only question which arises for consideration before this court is when can the official respondents pay the outstanding liability to the petitioner? The Learned State Council is granted last 3 weeks chance to come with proper and definite instructions
as to when the outstanding liability can be paid to the petitioner, listed after 3 weeks. Okay.
Right, Lordship.
For orders, item number 26.
Yes, Santi.
Lordship, I have already filed my counter affidavit on 6th of May. I am
Yes.
appearing for respondents 1, 2, and 3.
1, 2, and 3.
Yes, Lordship.
Lordship, we have received the.
Union of India.
Yes.
Union of India, 1, 2.
And 3.
NHIDCL.
Yes, Lordship.
What about the state government? Yes, Mr. LT. You have a very serious case here. Why no? You are the respondents. Vijmo.
Yes,
I think he is trying to escape.
I'll take it.
Yes, Mr. Yes, Mr.
Lordship, we have received a affidavit in operation 5 by respondent number 1, 2, and 3. Just today.
Okay.
So we may be allowed 3 weeks' time to file a reply.
Okay, what about Mr. LT? What about the state? Whether it will be necessary? You have filed? Heard, Mr. So-and-so?
Lordship, and service upon respondent number 9 is still away.
Oh.
That's counsel.
Heard, Mr. So-and-so? Learned counsel for the petitioner. Mr. Senti Younger. Learned standing counsel?
No, my lord.
Learned
That's counsel.
Okay, learned counsel for the respondent number 1, 2, and 3. And Mr. LT Sanctum, the learned counsel for the state respondents, Office note dated 6/5/2024 shows that notice on respondent number 9 still awaited. Mr. So-and-so, learned counsel for the petitioner, 6 for some time to file affidavit in reply to the affidavit in opposition filed by the respondent number 1, 2, and 3. Stop. Mr. LT Sanctum also prays for some time to file affidavit on behalf of the state respondents. Stop. Listed after 3 weeks for enabling the respondents, for enabling the petitioner to file the affidavit in reply and the state respondents to file affidavit in opposition. Listed. Okay, listed after 3 weeks.
Deeply obliged.
For hearing, item number 28.
Yes.
May I please, Lordship?
Ah.
Lordship, this matter is regarding posthumous regularization.
Posthumous?
Yes, sir.
It's a covered case, Your Lordship. The ratio laid down in Nishibi squarely covered the present case.
Yes.
Lordship,
Posthumous, I think.
There is one observation of the apex code that I would like to rely on.
What is that in the Nishevis case?
No, 1996 7 SEC 113, my lord.
Where what?
Where the apex code is observed that just because the employee at the time of his death was serving as temporary, simply doesn't deny the employee.
Okay, that is 1997. Okay.
1996.
1997. After 2006, where is the power of this court to regularize Oma Devi's case?
That's the CCS temporary service bills also covers.
No, not temporary. So you cannot. You take a chance before some other court. I will not be much inclined. Because actually this Nishevi's case is there
Thereafter, the division bench,
Alembas
the
case.
case, Alambas case is
Yes, Your
there.
Lordship.
And over and on top of all this, the Supreme Court, Honorable Supreme Court in the case of Uma Devi has clearly held that the High Court does not have the power to regularize the service unless your service is in accordance with the rules.
Lord,
The
misuse
posthumous
cases-
regularization, that has been settled.
Yes,
That has been
yes,
settled.
yes, Lord. Misuse case is a little different as in terms of
No,
delay.
posthumous regularization means what?
Posthumous.
The
Yes,
same principle of law
same.
will be applied. Come prepared. Come prepared. If you are really willing to argue, come prepared next week. But 1997, you cross-check with Uma Devi's case. You read the entire judgment. You read Nishivi's case. You read that Alambas case. And this Nishivi's case is particularly on the 2004 scheme. When did you resign? When did you retire?
She died on 2016 one.
2016. So 2015 scheme is applicable to you.
She
No,
served
no.
for
Which scheme you are
19
banking?
He doesn't come under that scheme, Your Lordship.
The petitioner has only served 19 years.
19 Yes, Your Lordship.
You're also hit by the scheme.
Yes.
Well, come prepared next week. Think over. We'll list it next week. But maybe you have a very big hurdle to cross. Okay. Who is your senior? Let him come. Let him come, at least. Let him come. Let him satisfy the score. Okay. Both of you together, I think you can somehow try to push up this case. But you have a big hurdle to cross. Okay. You tell him to come next week. Tell him, I want to hear him on this. Okay. List it again on. We give a date. You tell Mr. Moore to come.
1 week, Malam.
We'll give a date next week. This is for hearing, huh? Ma'am?
Yes,
For-
yes.
List it again on.
Next Tuesday, Malam.
Yes, on 14.
Yes, Malam.
Okay, listed again on 14/5/2024. You tell Mr. Moore to come. Okay. I think it will require the strength of both the senior as well as the junior to overcome this hurdle. Okay.
For hearing item number 29.
Yes, what is this?
Mr. Lordship, this writ petition is for grant of MSCB, Your Lordship. My prayer itself, if Your Lordship may. My prayer at page 14, Your Lordship. If I may read.
My God, you have so many prayers. You were regularized in service with effect from 1993.
In 1993, yes.
So you get your MSCP only thereafter.
Yes, that is my claim.
So how many this upgradation you are supposed to get?
Under the ACP one upgradation, it should be
Under the SCP 1?
ACP one, and then under the MSCP, your lordship, it should be one more, your lordship, if I'm not mistaken. Mm,
You were regularized in the year 1993.
93, yes.
So what is the
Officiating-
span for actually like entitling the benefit of
Under the
MSCP?
ACP, it was 12 years. your
12
lordship,
years.
12 years.
So your first SCP accrues on?
Since officiating promotion was in 2006. So starting from 93, 12 years,
Will be 2005.
yes, it will be 2005. Up to that, I'm entitled to the ACP.
Ah,
Then now, in
2005 to
2006, I was granted promotion. Promotion to UDA,
ah,
officiating promotion.
ah.
So now, starting from 2006 again, no, yes, 10 more years, because the MACP came into force in 2010.
2006?
Yes.
10 more years means 2026.
16.
2006? 2016.
2016,
So
yes.
you get a second upgradation.
Yes, yes. Up to that. And then the third one will be another 10 years.
From
That is the-
2016?
from
2000, you're still in
2026.
service.
So he has now retired.
When did he
And
retire?
then what, only recently, last year, your lordship, the exact.
But
date is
you have
yet.
not reached the tenure for your third MSCP.
Yes,
You have not reached your tenure of service.
no, with regard to the last one. So it is two MSc, two accreditations. One from 2003 to
1993 to
1993 to 2005.
2005?
And then from 2006, he was promoted.
2006 to 16.
Yes.
So the second
The second
application
one
is
will be from
10
2016.
years.
Yes.
That is
2000 yes. 10
MSCP.
years. MSCP 10 years.
And ACP 12 years.
ACP is 12 years.
What is the error? What is the error you are claiming?
That will be calculated by the department only. Your
No,
lordship.
that's
Yes,
why. Just give me a hint. What is the error you are claiming?
It will be based on a scale of pay, your lordship. So,
Okay, that we may
yes,
not
that
be.
will
able-
have to be worked out.
Yes, Miss Mary, if he is entitled pay,
Yes, yes, we are not denying that, Your Lordship.
Yes.
But Your Lordship, at the time of the filing of our affidavit, we have admitted that his case will be taken up. So after filing the affidavit, I have sought for an update on the status as to how it's going about. So regarding that, I received an instruction that the case of the petitioner could not be taken up due to ratification to regularization order of the officiating promotion. That date was disputed by the petitioner in another repetition. So that repetition has been disposed of recently, Your Lordship.
and what was that?
Basing on the corrigendum issued by the department, acceding to the prayer of the petitioner, Your Lordship. So now the matter may be disposed of because there won't be any hurdles now, Your Lordship. It's just because of a want of clarification to the date of the officiating promotion, the petitioner's case could not be taken up, Your Lordship.
So
If
what
I
is
may
the
be
date
allowed-
of, what is the date of promotion?
So date of promotion is with effective from the date of the
Officiating
officiating promotion,
promotion.
yes, not from
Ah.
the date of the DPC.
Correct,
That was, yes,
correct,
that
officiating
was,
promotion.
yes, yes, that was then corrected, Your Lordship, by issuing a corrigendum. So Your Lordship, a direction may be given, Your Lordship, because we are not denying, Your Lordship. He's entitled as per the ON. Strictly in
And
terms of-
what about the last order? Let
Yes,
me
yes,
see.
that, Your Lordship, in that.
Yes, in that first order.
Yes. Your Lordship,
Where, in which para?
Your Lordship,
Oh,
Your
this,
Lordship,
this is not legible. Oh, miss. You have a legible
Your Lordship,
copy?
the corrigendum copy is here, Your Lordship.
Acha.
I have only one copy.
So this corrigendum is issued consequent to this order.
No, basing on this corrigendum, that order was passed, Your Lordship.
Okay,
That
basing on the
yes.
corrigendum. Let's see.
And
Basing
And
on
Your
this
Lordship,
corrigendum,
yes,
acha,
Your
in
Lordship.
supposition of
and the subsequent
the
instruction, Your
officiating
Lordship.
promotion of from the date of officiating promotion to the post of user. So this settles the matter.
Yes, Your Lordship, and subsequent instruction.
And consequent to this order was passed.
Yes. The minutes of the last MSCP, Your Lordship.
You have less. What was the order?
131. That's what it is.
So even by this,
Yes.
even by this meeting minutes, even by this
It appears so, yes.
like officiating promotion,
Yes.
rectify the regularization.
Yes.
So this is when? This is when?
This was only recently, Your Worship.
This was
During
held
the
on
pendency of this
38,
case.
2022.
Yes.
38, 2022,
Yes.
and this after that, this corrigendum was passed.
Yes.
And on the basis of this corrigendum, this order was passed.
Yes.
And even my prayer does not contradict this because
Yes.
since he was demoted.
What is your prayer? Let us say again.
Nine. To direct the respondents to second one.
What about the errors, ma'am? What about the errors?
That will be the lookout of the committee, Your Lordship. If he is entitled, he will get, Your Lordship.
Yes.
So again, that'll maybe if there is some controversy, it may lead to again second round of litigation.
Your Lordship, they should act strictly in terms of the OM, Your Lordship. The OM is clear, Your Lordship.
The MSCB is very clear.
OM, which is that OM? Which is that OM? Let us see that OM.
Page 41. Lordship, it starts from page 39. Page 39?
Yes, wait, page 39.
Yes, the page 35 is with regard to the ACB, Your Lordship.
Page
35 to.
What is the
30
first page?
35 to 38 is the ACB.
ACP, this is after 12 years. You
Yes.
get your
Yes,
ACP after
yes,
12
yes,
years.
yes,
Yes.
And what is the
And-
next? This is ACP assured carriers.
Yes.
Where is the MSCP?
MSCB from 39.
Page 39.
Yes.
This is after 10 years.
Yes, yes.
Under the ACB, there were 2 upgradations, but by the ACB, three upgradations.
So you are, ma'am, you are not disputing the claim of the petitioner
Lordship.
that he is entitled to 2 ACPs. One ACP, one MSCP.
One MSCP.
After 12 years, 10 years.
10 years. As per the OM, Your Lordship, this entitlement, we are not denying, Your Lordship.
Why, Mr. Tongkok, why this writ petition was filed? Because of the dispute in the officiating promotion?
No,
No, he is
because the
different.
MSCB and the ACB were
Was not granted to
him.
him, yes.
at the relevant point of time when it ought to have been granted to him.
Okay, then we pass the order.
Yes, Your Lordship. And with regard to the third prayer, Your Lordship, I want to make a small clarification.
Huh.
With regard to the third.
What is your third prayer? Let us
Prayer
see.
is for granting of the
Error.
career progression scheme under the secretary scale of pay. That is the prayer now. But then by the recent judgment order which was passed, which has been placed before Your Lordship, by this, this honorable court has directed the department to decide on the matter, whether he is entitled to the secretary scale of pay or not. So if at all it is decided in his favor, then that issue can be.
What is that? In which part of your prayer? No. In your
Prayer
petition?
15, page
Page
15.
15, third. At this point of time, the other writ petition was pending, Your Lordship. Now it has been disposed of.
Third prayer may not be interfered with, Your Lordship, because in that WPC 131, liberty was given to the department to examine and come out with a finding whether he falls under secretariat level or district level.
So it will be subject to that decision
Yes.
based on this.
Yes.
Your Lordship.
So this SCP is in what scale? Directorate or secretariat?
It should be as in the normal scale, but in case he is decided to be granted the secretary scale.
Normal
of pay,
scale means in the directorate.
No, he is still getting the district scale.
District level.
District level.
Oh,
Pay
so
bank.
the ACP will be calculated as per the district scale.
Yes.
Since
Yes.
this decision is
It's yet to be finalized.
Decision on this matter is yet to be finalized. But once it is finalized, that it is, if at all, it is finalized that it is secretary scale, then again, it will be recalculated based on that.
Okay, heard Mr. Tongkok found the learned counsel for the petitioner and MS Esmeri, the learned senior government advocate for the state respondents. Okay, we pass the order. Okay.
For hearing item number 32.
Yes, Mrs. O.
My lord, this will be a short matter.
This is item 32.
Item number 32.
32.
Yes. WPC 252 of 2021.
Yes, Your Lordship.
Ma'am.
Lordship, I beg to mention on behalf of Inaudible Lordship, if this matter can come up on 16, Lordship. 16, Lordship.
16, it will be difficult. We listed on 21. On the prayer of the learned government advocate listed on 2024.
Obliged, Lordship.
Item number 37 to 41.
Yes, what is your case?
This petition is filed challenging the suspension of regular government employees. In a short matter, we are challenging the suspension order. These petitioners have been placed on the suspension for the last 4.5 years without any, there's a prolonged, without 4.5 years, almost 5 years under suspension, without any department inquiry, nothing. So I'm questioning the impure order on 2 points. One is whether prolonged suspension is justified. Prolonged suspension is justified.
There is that Supreme Court case. What Ajay Kumar's case?
Even apart from that, prolonged suspension is justified, not justified. I have also some.
No, if your case falls in that Ajay Kumar's case, yes, Mr. Kiangami.
Yes, Lordship, I'm contesting that. The contention is that based on the earlier judgment in 1964, the judgment rendered by the Ajay Kumar case does not, no discussion was made on those 2 other cases which are earlier rendered in 1960s, Lordship.
No, what about the latest on suspension is Ajay Kumar?
Lordship.
The latest decision of the Supreme Court is on Ajay Kumar on suspension.
Lordship, that is, but Lordship knows better, but that is 2-judge bench. Now I'm relying on 5-judge bench, the constitution bench, Lordship.
5-judge bench or
Supreme Court or the Supreme Court.
What it says?
Says that
as far as review is concerned, Ajay Kumar is the final judgment due.
What your judgment says? Just give me the gist.
Says that suspension is necessary, Lordship.
No, that is okay. That is okay. But apart from that, I think Ajay Kumar's case has clearly laid down the law. Suspension is necessary. That is okay. That is a. But in order to avoid prolonged suspension without any DP, without any departmental inquiry.
So if proper hearing may be heard, then I can illustrate. Was thoroughly discussed by.
No. What is your judgment?
I'll read it then, paragraph 10. Another, that is, Lordship, this is R.P. Kapoor versus Union of India and others. EIR 1964 SC 787, Lordship. Paragraph 10. Another argument is that is urged on behalf of the respondent is that suspension pending a departmental inquiry or pending a criminal proceeding cannot be said to be a disciplinary matter at all. And therefore, the protection of Article 371 does not extend to such suspension. We cannot accept this argument. The word disciplinary matters with which we are concerned appear in the constitutional provision and must be given the widest meaning consistent with what disciplinary matters may reasonably include. Suspension is of 2 kinds, namely as a punishment or as an interim measure pending a departmental inquiry or pending a criminal proceeding. We shall deal with this concern. We shall deal with this aspect of suspension in detail later. So far as suspension as a punishment is concerned, it is considered that it is a disciplinary matter. The dispute is only as a suspension pending a departmental inquiry or pending criminal proceedings. There can, in our opinion, be no doubt that a suspension of this kind also must be comprised within this, the words disciplinary matters as used in Article 214. Take the case of suspension pending a department inquiry. The purpose of such a suspension is generally to facilitate a departmental inquiry and to ensure that while such inquiry is going on, it may relate to serious lapses on the part of a public servant. He is not in the position to misuse his authority in the same way in which he might have been charged to have done so in the inquiry. In such a case, suspension pending and department inquiry cannot be but a matter ultimately related to disciplinary matters. Take again the case where suspension is pending criminal proceedings. The usual ground for suspension pending a criminal proceeding is that the charge is connected with his position as a government servant or is likely to embarrass him in the discharge of his duties or involve moral turpitude. In such a case, a public servant may be suspended pending investigation, inquiry, or trial relating to a criminal charge. Such suspension also, in our opinion, is clearly related to disciplinary matters.
No, that is okay. That is suspension. That is actually like okay. But
Lordship,
I think Ajay Kumar's case, I think it has a further actually like a stretch, like when suspension should end.
My lord, in this case, if the judgment which my learned friend has referred is clearly stated at paragraph 7, which I just presented. What is the issue here? In the same case, which my friend has paragraph 7, the only question that has been debated, before us is with respect to suspension, whether as a punishment or otherwise. In this case, not other things. No review is discussed about anything. Whether punishment can be taken as punitive or not, only that much was debated. Paragraph 7 is simple.
Let us see that. Let us see that that Ajay Kumar or
Yeah, Ajay Kumar.
let us see that case.
About paragraph 2021.
Mr. Kyangami, Ajay Kumar's case.
Yes.
Ajay Kumar case was decided so that a government employee is not under perpetual suspension.
Lordship, Lordship, yes.
Yes.
Because Ajay Kumar became the law of the land till today. We have thousands of judgments based on that. Supreme Court as well as High Court. Mary.
Yes, which is that relevant paragraph?
Page 302, page 2, paragraph 20. and
Page 302.
302. 302 page. Relevant page. Paragraph 20.
302.
Yes. Based on that, so many judgments have been passed. I'll show 1, 2 judgments. May I read it, my lord? It will be useful to recall that prior to 1973, an accused would be detained for continuous and consecutive period of 15 days. After judicial scrutiny and supervision, the Code of Criminal Procedure 1973 contains a new proviso which has the effect of circumscribing the power of the magistrate to authorize detention of an accused person beyond a period of 90 days, where the investigation relates to an offense punishable with death, imprisonment for life, or imprisonment for a term of not less than 10 years, and beyond a period of 60 days, where the investigation relates to any other offense. Going before from the observation contained in the division bench of Federal case versus Bihar, and more so of the constitutional bench of Soisho, we are spurred to extrapolate the 20 cents of the proviso to section 167 2 CRPC 1973 to moderate suspension orders in cases of departmental / disciplinary inquiries also. It seems to us that if Parliament consider it necessary that a person be released from incarceration after the expiry of 90 days, even though accused of commission of the most heinous crimes, uh, for, for sure, suspension should not be continued after the expiry of the similar period, especially when a memorandum of charges / charge sheet has not been served on the suspended person. It is true that the proviso to section 167(2) CRPC postulates personal freedom, but respect and preservation of human dignity as well as the right to a speedy trial should also be placed on the same pedestal.
Just
21.
wait, just
We-
wait,
we
just wait,
therefore-
just wait. Now, this here. Whether memorandum of charge
Yes.
has been served to the suspended officer.
Yes, in our case. So that is replied at paragraph 21.
Okay, let us see.
We, the, may I read my 21?
Yes.
We therefore direct that the currency of a suspension order should not extend beyond 3 months. If within this period, the memorandum of charges / charge sheet is not served on the delinquent official / complaint. If, here it comes my case, if the memorandum of charges / charge sheet is served, a reason order must be passed for the extension of the suspension. That much. So till today, no reason order has been passed. Why the suspension should be reviewed? That is my case. As in the case in hand, the government is free to transfer the person concerned to any department in any of its offices within or outside the state, so as to sever any local or personal contact that he may have and which he may misuse for obstructing the investigation against him. The government may also prohibit him from contacting any person or handling records and documents till the stage of his having to prepare his defense. We think this will adequately safeguard the universally recognized principle of human dignity and the right to a speedy trial, and shall also preserve the interest of the government in the prosecution. We recognize that the previous constitutional benches have been reluctant to force proceedings on the grounds of delay and to set time limits in their duration. However, the imposition of a limit on the period of suspension has not been discussed in prior case law. Same thing in that case, with my learned friend, that review was not discussed and would not be contrary to the interest of justice. Furthermore, the direction of the Central Vigilance Commission that pending a criminal investigation, departmental proceedings are to be held in the abeyance stands superseded in view of the stand adopted by us. So therefore, in our case, my lord, simple. Memorandum was served till today, no inquiry.
When was the memorandum of charge? When?
Was served 17/3/2020.
17/3/2020.
Till today, no trial, no inquiry.
No proceedings, no reasoned order.
Nothing. Till today, no review order, no proceeding.
No reason. Why have you not passed any reason order?
Trial is going on, right?
No.
Criminal case is going on. My learned friend is leading the case.
No.
He should have precedent for speedy trial.
No. My lord, that is different aspect. Criminal trial is different aspect. I'm talking about departmental inquiry. That is, nothing has taken place till today. Criminal trial is going on. We are passing degrees.
That is okay. Criminal trial is okay.
Department proceeding independent.
Whether after the charge sheet has been submitted,
Nothing.
whether any departmental proceedings has been initiated.
Nothing at all. Nothing.
Yes.
That is the point.
Criminal trial, okay. Let us
We're facing.
segregate criminal trial now. What about departmental proceedings, Mr. K. Angami? Are you able to justify?
Lordship, yes, here they're also waiting for the outcome of the last information our instruction received was waiting for the outcome of the
criminal case.
No. That is a wrong stand. That is a wrong stand. You know the law that both criminal as well as departmental proceedings can proceed parallelly.
Parallel, yes, that is quite independent. So there's no escape.
So I think if there is no reason order, extending the suspension, then his case squarely falls under this.
Lordship, yes, I.
Sometimes you
Lordship,
do justice to the code.
Lordship, but even for the sake of academic discussion, I want to like adopt one thorough discussion made on this same judgment by a constitutional bench of Madras High Court, three judges bench, Lordship.
Madras High Court?
Yes.
How can the Madras High Court?
They have discussed thoroughly on this topic and on this Ajay Kumar. Then the discussion also made on how the case in Ajay Kumar did not discuss.
Okay, let us just hear that Ajay Kumar's discussion. Because even our own High Court has adopted this Ajay Kumar. Mr. Even our own High Court has in many cases adopted this.
Yes.
Our division bench high court, separate,
Yes.
hundreds of cases.
We have also passed many orders.
Yes, Your Lordship.
So when our own High Court order is there,
Including high court division.
it may not be necessary for us to rely on the Madras High Court.
But Lordship, we know that it has persuasive value, and the one I'm relying
Persuasive
is-
value, but actually when no decision has been rendered by our own High Court.
Lordship.
Maybe it has persuasive value, but when our High Court, maybe if I have not gone through the Madras, but if our own High Court has taken a different stand, we are bound to follow our High Court.
My lord, till 2024, till this year, our high court.
Yes.
has followed.
Anyhow, what is that? Let us see whether there is any value. Where is that? Which?
Lordship, I want to start from paragraph 14, Lordship. Of the Madras High Court, Lordship.
Paragraph
14, Lordship. 14, if you my lord can have patience to hear till 30, paragraph 30, Lordship. It's very loose.
Paragraph
14 to 30, Lordship.
14 to 30.
Lordship. Actually sounds bulky, but not very tight.
Paragraph 14 to 30.
Lordship. Here, this was also discussed about.
Let us see that specific paragraph where this Ajay Kumar's case was discussed. Whether the Ajay Kumar's case was discussed.
Yes, Lordship.
Para 22, is it?
It starts from 14, Lordship. 14, then 16 also, Lordship.
Para 14?
Yes.
I'm not getting your para 14, no?
Page.
Para 14 to?
Para 30, Lordship.
Para 14 to 30?
Lordship. Page 16. 16. Of flag.
Okay, let us see, come.
Before addressing the issue about the applicability of the ratio propounded by the Supreme Court, it would be relevant to refer the judgment of the Supreme Court in the case of Ajay Kumar Chaudhary Supra. The judgment aforesaid has been heavily relied upon by the learned counsel for the petitioners. Before referring to the relevant paragraph of the judgment aforesaid as relied upon by the learned counsel for the petitioners, it would be relevant to narrate the facts of the said case. The delinquent officer prepared a note that approximately 4 acres of land were not defense lands, but were private lands in respect of which NOCs could be issued. Based on the note aforesaid, NOCs were issued by the appellant, followed by his transfer. The NOCs granted by the appellant resulted in the action against him, and he was thus placed under suspension from 30/9/2011. Challenge to the order of the suspension beyond the period of 180 days was made. The challenge could not sustain, and ultimately the matter went to Supreme Court. When the matter reached the Supreme Court in the year 2015, a period of 4 years had already elapsed, and in between the charge sheet in the criminal case was submitted. In view of the above, the apex court refused to cause interference in the order of suspension with the observation that whatever finding has been recorded may not be relevant to the appellant therein. However, it was observed that if the appellant is so advised, he may challenge the continued suspension in any manner known to law. The relevant paragraph heavily relied upon by learned counsel for the petitioner in paragraph 21 of the aforesaid judgment. However, it is to be considered in the light of the facts given above. Worship, I think we can skip we may skip.
This is 21, 22 is
Yes,
Ajay
my-
Kumar's.
Yes, my learned.
Now, so what was the finding of this court? There's the Honorable Madras High Court?
They say that does not look absolute proposition of law.
Pardon?
Absolute proposition of law is not laid down by the
Let us see where.
that is at paragraph 30, Lordship. Now,
Where is that finding? You are not giving me that definite finding. The discussion on Ajay Kumar's case.
30 page, paragraph 30, Lordship. Or the last one, Lordship, last page, last second page, last third page, Lordship. Paragraph 34. Page 44, Lordship. For the foregoing reasons, the reference is answered by holding that the judgment of the apex court in the case of Ajay Kumar Supra does not lay down absolute proposition of law that an order of suspension cannot be continued beyond the period of 3 months if the memorandum of charge sheet has not been served within 3 months, or if memorandum or charge sheet is served without reason order of extension. The judgment in Balaji Supra has no reference to the earlier judgment of co-equal strength and is thereby rendered per incurium. The issue of challenge to the order of suspension should be analyzed on the facts of each case, considering the gravity of the charges and the rules applicable. Revocation of suspension with a direction to the employer to post the delinquent in a non-sensitive post cannot be endorsed or directed as a matter of course. It has to be based on facts of each case and after noticing the reason for the delay in serving the memorandum of charge sheet.
What is, or if the memorandum of charge sheet is served without reason order of extension. What is the latest judgment of our own High Court?
My Lord, this is division by 2019.
Mr. Kya Hangami, maybe I will have to go by the decision laid down by the Supreme Court.
My Lord,
Lordship, but I'm also relying on Supreme Court, Lordship.
my Lord,
if my lord may take me, if I may take my lord to some of the observation made by this Madras High Court, they have how they have discussed about this case and how they have make a discussion on the previous case in 1960s, Lordship.
Lordship will permit me to say, I have gone through that one. Madras has only their observation. They have not, they have no power to set aside Supreme Court judgment, number one. Number two, they have not declared that Supreme judgment is binding law. Only observation I don't see.
I'm also saying that.
Number two, my lord, the judgment which my learned friend has Supreme Court judgment 1964. That was prior to 1973 CRPC amendment. So therefore, this Ajay Kumar's case, the principle in Ajay Kumar's case, the principle has been laid down based on criminal procedure code 1973.
Exactly, Lordship.
1964 criminal law has not been amended in 1973. Therefore, the relevancy of 1964, there is no, it will not find any place here.
No, so
Ajay Kumar's case has been the law, the people laid down.
Let us say one of our own High Court judgments, depending on this. Ajay.
Division bench. JLT 2019 volume 5.
Let us see.
This was passed by Justice Sarko and then Manish Chaudhary.
Let us
Same
see.
case.
Where is that para?
I'll just take worship paragraph 12. And there are hundreds of judgments that follow our own High Court. I have so many judgments, same principle. Paragraph 12. And then my paragraph 18. Last. Short. In view of the aforesaid discussion, we are of the considered view that the letter single judge is not unjustified in reaching the ultimate conclusion that the period of suspension of the respondent in absence of any reasonable order passed in review cannot be prolonged and therefore is justified in setting aside the order of suspension that is 6 and 17 in respect of the respondent. Consequently, we do not.
In view of the aforesaid discussion,
State file appeal. So state appeal was dismissed. For the letter civil judge, Justice LS passed the order that was challenged by the state. Then this was decided by the division bench. Then the division bench has upheld the decisions of the letter civil judge. Based on Ajay Kumar's our own High Court 2024 this year. My lord, this is passed on 12 February 2024 by my lord Justice Sumitra Saikia, based on the same principle, my lord. If lordship permits me to read, just it's a short judgment. May I read it from page 2, my lord? By this writ petition is filed by petitioner, who is aggrieved by the suspension order dated 2010-2023, whereby the petitioner was placed under suspension by the respondent tree. The petitioner was serving as an assistant professor in B. Borwa College, Ulubari, Gauhati. During her service, the petitioner was arrested on 12/10/23 in connection with PS number so under section 14 of the Child Labor Prohibition and Regulation Act 1986, under section 4A of POCSO Act 2012, and under section 75 and 77 of JJ Act. The petitioner was subsequently released on bail by order dated 30/11/23, passed by the Court of Special Court POCSO, Kamru, Gauhati. Since the petitioner was taken into custody in connection with dispute case number so, she was suspended by the respondent 3 by an order dated 2010-2023. Revised of the petitioner that since the date of issuing of the suspension order dated 2010-23 till date, the petitioner is under suspension and pursuant to the said suspension order, no review for further continuation of suspension has been undertaken by the authority concerned. An appeal dated 24/1/2024 was also filed before the respondent 2 requesting for reinstatement. However, the same has not been redressed as on date. Finding no alternative, the petitioner has opposed this court by filing the present petition. Learned counsel for the petitioner submit that there was no inquiry conducted against the petitioner and therefore there is no question of imposing any penalty. It is submitted that no review of the suspension has been conducted and the same is not disputed by the learned standing counsel, higher education department. Having heard the learned counsel for the parties and upon perusal of the records, it is saying that the petitioner was put under suspension by order 2010-23 during her service. Has been essayed in the present proceedings on the ground that, as mandated by the law, the review of requirement of continuation of putting the petitioner under suspension was not carried out, and therefore the suspension order dated 2010-23 is required to be interfered with. Having heard the learned counsel for the parties and upon careful perusal of the writ petition, this court is of the view that time and again Supreme Court as well as this court had passed several orders interfering with the suspension order where there is a failure on the part of competent authority to review the continuance of the suspension as mandated by law. This law has been clearly laid down by the Appellate Court in Ajay Kumar Chaudhary versus University of 24, reported 2015, 7th SEC 24, and this judgment has been followed by this honorable division benches as well as several other coordinate bench of this court in several judgments. It is to be noted herein that the question as to whether the discipline process authority will be entitled to place an employee under prolonged suspension without reviewing the order of suspension came up for consideration before the Honorable Supreme Court in the case of Ajay Kumar Chaudhary. The finding of Appellate Court in para 20 and 21 of the said judgment would be relevant in the facts of this case and are therefore extracted below. My lord, I will need to read the lordship has gone through. Then I'll come to next page 7, page 6, man. Page 6. The ratio laid down in Ajay Kumar Sutra has been applied by the Honorable Division Bench of this court in so versus State of Assam, reported 2019, volume 5, wherein it has held that the principle laid down Ajay Kumar Chaudhary will be applicable in cases suspension under Rule so of Assam Services Discipline and Rules 64 also. Same view was also rendered by another different bench of this court in state of Assam versus so. In its judgment and order dated 2/3/23, coordinate bench have also applied this ratio in Rafet Ali Ahmed versus State Assam in WPC so and Tapang Das versus State of Assam by its judgment and order dated 16/11/23 in WPC so. In view of such authoritative finding of the appellate court, and which law is followed by the different bench and other coordinate benches of this court, the authorities are duty bound in law to comply with the principle laid down by the appellate court in Ajay Kumar's judgment. So that is final one.
Okay, we'll list it again on Monday. That's the first hearing item. But Mr. Kyangami, I think you will have to overcome this Ajay Kumar's case. Come prepared. Come prepared. Not hovering around suspension, but come direct to the point.
Yes, I'll try to come to that. Basing on those two Supreme Court judgment, Lordship.
Which two?
I've only submitted one is Kem Chang and the other one I've read.
Kem Chang, 1964.
Yes. Now, and even the discussion in the Madras High Court, what they made was the CRPC. Now, the analogy of 90 days was drawn for the submission of charge sheet. Now, in case of like NDPS, it is 180 days.
I think you will have to go in appeal. I am making my intentions clear. With so many authoritative judgments of the Supreme Court and of our own division bench and not a single judge, coordinate bench. I think you will have some obstacle to cross over.
Lordship, but at least for this.
We'll record your
For
statement.
academic discussion also, Lordship.
So this will not be by way of an order, maybe this will be by way of a judgment.
Lordship.
So we will hear you properly, but you also come prepared as to how to overcome this Ajay Kumar's judgment.
Lordship, in that case, is that possible Tuesday, Lordship?
Tuesday, I think the more it goes back, I think the more difficult it will be for this court, because this court will not be able to carry all these bunches of files and then go here and there. Monday, we will list it at first hearing item.
Yes.
Okay. Heard Mr. So-and-so, Mr. Aship Ezo, learned counsel for the petitioner, and Mr. Kyangami, the learned senior government advocate. Listed again on 13/5/2024 as the first hearing item. Okay, as the first hearing item. We want to visit the new court complex today, so we have a shortage of time. Okay, keep all this, okay? Keep all this. Keep all these books, okay? Keep all these books for this, okay?
Gauhati was